Grant Cardone lost his appeal in the Ninth Circuit Court of Appeals. And what does that mean for YouTubers all across the world? Hey, this is Drew Page. Welcome to the Drew Page channel. In this video, we're going to break down the opinion that was given by the Ninth Circuit Court of Appeals that was published, as well as the unpublished memorandum that has left some people baffled as to what the Ninth Circuit actually did with Grant Cardone's case, because it says that part of it was affirmed and part of it was reversed. So what are we talking about here? There have been some channels that have had this question about what actually happened, and unfortunately I'm just getting to it, but we're going to go into it today. So I hope you enjoy this video. If you do, please like the video. It definitely help my channel out, help get the information out there to help people. And please subscribe to the channel. You can get all the videos, be kept up to date. And please put down in the comments if you have any questions, you have any comments, things that you want to let me know about, or topics you'd like to discuss further. Or if you have any opinions about what the Ninth Circuit did in this case, just put them down in the comment section below, and I look forward to responding to as many of them as I can. So back in December of 2022, the Ninth Circuit Court of Appeals made a ruling on Grant Cardone's case involving Luis Pino. I've done a full video on the claims that Luis Pino made in his complaint in another video, and I'll try to put the link down in the description if you want to follow all of that. So I'm not going to go through all of what happened in this particular case. Suffice it to say that he was an investor in funds 5 and 6 of Cardone Capital, and that he made a claim that Grant Cardone made materially misleading statements and that he was a statutory seller, and sued him under the Securities Claims Act, and saying that he was in violation of these laws and regulations under the Securities Act. So what the Court of Appeals did was, in a published opinion, it addressed the issue of whether Grant Cardone qualified as a statutory seller. And then in the accompanying memorandum that was unpublished, it dealt with the issues regarding what the material misleading statements were, and which ones were actionable and which ones are not actionable. So if you don't read the accompanying memorandum, you don't really know what the court did with the entirety of the case. So you actually have to read both, and fortunately for you, I have both. So let's start off with what was published by the Court of Appeals. Now, it's important to remember where this case was at in the district court. It had not reached trial. It had not even reached discovery. In fact, what had happened was the district court granted Grant Cardone's 12B6 motion to dismiss for failure to state a claim upon which relief can be granted, saying essentially that the complaint that Luis Pino filed was defective and did not state a claim, and therefore could not go forward. It was allowed a first amended complaint, but then once the court made a dismissal of the First Amendment complaint, they said that they would not grant leave to amend, which means that Luis Pino could not fix the defects in the complaint. And that is what Pino appealed to the Court of Appeals. And in the published opinion, the only question is whether there was a plausibly stated claim that Cardone and Cardone Capital qualify as statutory sellers under the Securities Act. And to this issue, they reverse in part and affirm the case in part, but the affirmation comes with the memo. So it is kind of confusing, and I understand why people are confused about it. But nothing in the published opinion is actually affirmed other than what they're incorporating about the memorandum that's also referenced. So on page 5 of the published opinion, it says, the First Amendment complaint alleges that when Fund 5 closed, Cardone posted on the Cardone Capital Instagram account that Fund 5 is the first regulation A of its kind to raise $50 million in crowdfunding using social media, and that by accessing social media, I am offering investment opportunities to the everyday investor like you. And so that was one of the statements that Pino alleged was a solicitation that he was trying to sell. And then he also alleged Grant Cardone made the statement, by using no middleman and going directly to the public using social media, we reduce our cost. This ensures more of your money goes directly into the assets, resulting in lower promotional costs. And so the opinion goes later in page 6. It says, in a YouTube video on April 22nd, 2019, Cardone states, it doesn't matter whether the investor is accredited or non-accredited, you're going to walk away with a 15% annualized return. If I'm in that deal for 10 years, you're going to earn 150%. You can tell the SEC that's what I said it would be. They call me Uncle G, and some people call me Nostradamus, because I'm predicting the future, dude. This is what's going to happen. So that's another statement that Pino alleges, and in the video I did on the complaint that was previously dismissed, I mentioned all this in the video. So based on the claims that Pino made, the defendants made a motion to dismiss under 12b-6, and the court granted it. Now, the standard of review for the dismissal of a complaint without having a trial or any of that is de novo, which means that the court does not have to give any credence to the district court's decision, which would be an abuse of discretion standard if they had gone to trial. Or unless there was some legal issue. But since this is a legal question, it is de novo, which means they get to come at it fresh and make a fresh decision. They say the only issue we decide here is whether Cardone and Cardone Capital count as persons who offer or sell securities under Section 12A based on their social media communications to prospective investors. On page 9, they explain what is needed in order to be a statutory seller. If the person, one, passes title to the securities to the plaintiff, which there's no allegation that they actually passed the title, or two, engages in solicitation, and they have this in quotes, i.e. solicits the purchase of the securities, motivated at least in part by a desire to serve his own financial interests or those of the securities owner. So you're going to see that this particular kind of language is going to pose problems not just for Grant Cardone, but also for other YouTubers who may be facing lawsuits because they may be considered having engaged in solicitation as the Ninth Circuit understands it, and as you'll also see that another circuit court also holds this view of statutory sellers. So this is going to potentially have impact not just on Grant Cardone's case, but on many YouTube channels where they are engaging in solicitation to get people to purchase a security if it benefits them financially. On page 9, further down, it says the question then is whether Cardone and Cardone Capital engaged in solicitation. Now, the Ninth Circuit notes that neither the Supreme Court or the Ninth Circuit has given an opinion about whether solicitation must be directed or targeted towards a particular individual under Section 12 of the Securities Act. So then they say, all right, so there's no primary authority, which essentially means that something that is binding precedent. There's nothing that binds them to decide this question one way or the other. So what they do, since there's no primary authorities, they go to secondary authority, which would be from another court. They look at state courts, they look at other circuit courts, they can look at district courts, they can look at other state statutes, things that kind of help give guidance, but it's not mandatory authority, it's persuasive authority. And so they go to the 11th Circuit, who does not offer binding authority to the 9th Circuit, but persuasive authority. And it says that the 11th Circuit recently held that videos posted publicly on YouTube and similar websites can constitute solicitation under Section 12, even if the offering's promoters did not directly target the particular purchasers. So the 11th Circuit's already answered this question in the affirmative. If you post a video that is mass solicitation, mass communication to try to get people to solicit them to purchase a security, that counts as a statutory seller under Section 12. So this, of course, the FTX stuff and the other claims of solicitations of securities on YouTube channels and things like that, this opinion has some very strong impact on this particular area, which is, of course, why I don't do sponsors. I've had several emails about sponsors for the channel. I just don't want to do it. I don't need it anyway. I do this as a service to you, to help you, and to educate you on the law and things that are going on. But I don't do sponsors for this very reason, because I don't want someone to come after me saying that I tried to solicit them into purchasing some security or thing like that. So, I don't necessarily fault people for doing that, but obviously it just opens up the door for potential problems. And if you do those types of things, you definitely should consider getting insurance, creator insurance, things like that, to protect yourself. They say that solicitation means that is when a person must urge or persuade another to buy a particular security, but those efforts at persuasion need not be personal or individualized. So that's what the 11th Circuit has to say on the matter. Interestingly, the Securities Act was passed back in 1933, before the internet. So the problem that the Ninth Circuit has is that the Securities Act does not address the issue of mass communication by internet. So it points out the fact that to offer for sale in a prospectus means any prospectus, notice, circular, advertisement, letter, or communication, comma, written or by radio or television. And they say that while it doesn't include internet, the fact that it includes radio or television says that they are intending to prevent the issue of mass communication solicitation by materially misleading statements. They're basically saying that, yeah, the internet's not in here, but it's kind of in here because it's included under radio and television. So then they go into the actual analysis of the case. It says, in fact, if anything, the advertisements at issue in this case, Instagram posts and YouTube videos, are the types of potentially injurious solicitations that are intended to command attention and persuade potential purchasers to invest in the funds during the most critical first stage of a selling transaction, when the buyer becomes involved. He says, the opinion says, in this case, defendants allegedly relied significantly on social media to source investors for the funds at issue here. Cardone posted on social media that Fund 5 was funded through crowdfunding using social media, and touted the use of social media as an intentional strategy to reduce promotional costs. So they're saying, of course it's solicitation, because he's claiming it was solicitation. The way we're raising money, the way we're soliciting, is by using social media, and that we're doing it in this big way, bigger than anyone else. So they say, we conclude that Section 12 contains no requirement that a solicitation be directed or targeted to a particular plaintiff, and accordingly join the 11th Circuit in holding a person can solicit a purchase within the meaning of the Securities Act by promoting the sale of a security in a mass communication. So they are essentially arguing that Pino can amend his complaint in accordance with their particular rulings of court, so that they can allege that he was a statutory seller for these reasons based on those particular communications. Now, what are the communications that the Court of Appeals are relying upon? Well, let's take a look at the memorandum. So the materially misleading statements regarding the rate of return, as well as the distributions the court holds are actionable. Those are the statements that will be attached along with the fact that Grant Cardone and Cardone Capital are statutory sellers, as the Ninth Circuit has determined. And so now Pino can attach the claims regarding the rate of return, where Cardone says that you'll get 15%, that he's called Uncle G, but some people call him Nostradamus. You're going to get 15%. That is an actionable statement, materially misleading statement. And then regarding the distributions as well, under Cardone Capital, what they're going to get when the distribution time comes is a materially misleading statement. So they can continue with those. Nevertheless, there are some statements that Pino alleges that does not meet the materially misleading requirements, as the Ninth Circuit has determined in this unpublished memorandum. The first is that the district court did not err in holding that misrepresentations or omissions made in the Fund 5 and 6 offering circulars themselves are not actionable. So the statements that were in the circulars are not actionable. Pino did not sufficiently allege that the descriptions in the offering circulars of defendant's strategy to purchase properties below market value was misleading. So what were those statements? One, that the offering circulars represented the fund's strategy was to acquire multifamily apartment communities at below market prices, when in fact Cardone and Cardone Capital purchased the Del Rey property at a high price to maximize their fee. So he doesn't get to argue that. It's two, that the offering circulars represented that necessary financing would be secured before properties were obtained, when in fact Cardone purchased the properties from third parties before selling them to the funds without informing investors. And three, the funds did not disclose that Cardone charged investors interest on money loan to the fund to acquire properties. So those statements are out. Even with the amended complaint, the Ninth Circuit says you can't use those. So the below market value purchase of the sole property, the Del Rey property, he doesn't get to continue with that argument. In addition, it says any alleged omission regarding Cardone receiving an acquisition fee from the sale of the Delray property in the Fund 5 offering is also not actionable. And then for the same reason, the district court correctly dismissed Pino's claims that the funds did not disclose that Cardone Capital was extending commercially unnecessary interest-bearing loans to the funds is also out. Because the circulars had indicated the potential conflicts of interest that could arise as a result of Cardone and Cardone Capital and its affiliates, and they had sole discretion on loan purchases, what properties to purchase, and things like that. So those warnings and cautionary language were in there, and so the Ninth Circuit says Pino does not get to bring those. So the court reverses the district court's dismissal of Pino's Section 12A2 and 15 claims as to defendants' alleged statements regarding a 15% IRR in distributions as well as the fund's debt obligations. But as to the other statements regarding the circulars, those are out. So I hope that helps. I hope that answers questions for those who are wondering what was affirmed by the Ninth Circuit versus what was reversed. It's a very interesting opinion, and it speaks a lot to YouTubers. So be very careful before you take a sponsor. And there are better ways to make money than not doing the research, just taking a sponsor from a creative agency and you're soliciting on their behalf, and then you get popped with a lawsuit for being engaged in solicitation. So be careful about that. Let me know what you think. Do you think that the Ninth Circuit got it right? Do you believe that Grant Cardone is a statutory seller? And if so, do you believe that when this goes to trial that Grant Cardone is going to win? Let me know down in the comments, and look forward to seeing what the court does as this progresses through discovery and perhaps trial. So again, I'm Drew Page. Thank you for watching the Drew Page channel. Please like the video, subscribe to the channel, and until next time, stay tuned.